Well, I've got here the actual original brace that this letter was responsive to.
When did Congress pass a law saying pistol braces qualified? This pistol brace was sold in 2012. A guy walked into a gun store, bought it legally, walked out of the gun store with the pistol brace.
So you say that the brace changed, and so you had to implement this rule. Are you telling me that this brace is exempt from your rule?
Bruen decision and its aftermath. The issue of concealed carry bans is once again before the Supreme Court, and the recent development sheds light on what the court may decide next regarding states like New York, which are challenging the Bruen decision. Let's delve into the latest developments. Let's begin by looking into the ongoing issue of concealed carry and the defiance of Second Amendment rights, particularly in light of the Supreme Court's recent Bruen decision. Recently, 5 cases were expedited and heard by the Second Circuit Court of Appeals due to concerns raised by the Supreme Court about the Second Circuit's resistance to Bruen. These cases challenge New York's new Concealed Carry Improvement Act, CCIA, a highly restrictive law hastily enacted just 8 days after the Supreme Court's landmark 6-3 decision in Bruen. Despite the clear directive from the Supreme Court, New York and the Second Circuit persist in their defiance. Now, Guns of America has petitioned the Supreme Court to reconsider their Antonia case, seeking once more to overturn New York's defiance and dismantle these concealed carry bans. What's particularly intriguing is the procedural turn. Antonia's case was scheduled for conference, but instead of a decision or relisting, it has been placed on hold. This move carries significant implications for the future of this case. The Antonia case. What appears to be unfolding now is that the Antonia case has been suspended pending the Supreme Court's decision in the Rahimi case. Recently, Justice Thomas authored the decision on the cargo bump stock case, suggesting that Justice Alito may likely be tasked with writing the Rahimi decision. This development holds promise, as Alito is expected to craft a thorough and impactful opinion. The Rahimi case is poised to apply the principles established in Bruen, particularly concerning restrictions related to domestic violence restraining orders, which are directly contested in Rahimi. With Antonia now on hold, it suggests that its outcome hinges on the Rahimi decision. The linkage implies that Rahimi will significantly influence not only this concealed carry dispute, but also potentially other Second Amendment cases. Once Rahimi is decided, it's anticipated that Antonia may undergo a process of grant, vacate, and remand. For those unfamiliar with Bruen, the Supreme Court invalidated New York's original May issue CCW licensing scheme, ruling it inconsistent with America's historical norms. A critical aspect of Bruen was establishing that the government must substantiate that its regulations align with long-standing traditions dating back to 1791. Despite the Supreme Court's decisive 6-3 ruling in Bruen, New York swiftly enacted the Concealed Carry Improvement Act, CCIA, just days later. The CCIA significantly intensified the restrictive framework that existed before the Bruen decision. This New York law, crafted in direct response to Bruen, faced legal challenges in federal district courts, including the Antonia case brought by the Gun Owners of America. Initially, Antonia sought emergency Supreme Court review due to developments at the district court level. Initially, the district court ruled in favor and granted a preliminary injunction, but the Second Circuit subsequently imposed blanket stays, effectively halting the injunction's enforcement. In the first attempt, Antonia petitioned for emergency Supreme Court review, which was denied. However, Justice Alito's statement accompanying the denial underscored the Second Circuit's obligation to either justify its blanket stay or expedite case hearings. Consequently, the Second Circuit opted for expedited hearings. Recent developments. The Second Circuit. Recently, the Second Circuit conducted hearings and rendered decisions on all 5 cases challenging the CCIA. The pivotal Antoniuk case, which contested the broad restrictions, location provisions, and permit process of the CCIA, was at the forefront. The Second Circuit ultimately overturned the lower court's decision, vacating the preliminary injunction it had granted. In their ruling, the Second Circuit attempted to differentiate Bruen as an exceptional case, asserting that its precedent did not align with Antoniuk's circumstances. They characterized Bruen as unique, addressing issues they deemed extraordinary, while viewing Antoniuk and the CCIA as distinct and not falling within Bruen's exceptional category. In response to this Second Circuit ruling, the Gun Owners of America, GOA, have filed a petition for Supreme Court review. Although the case remains at an interlocutory stage, its direct relevance to Bruen and New York's direct response to that landmark decision make it a compelling candidate for Supreme Court review. Moreover, the Supreme Court had previously hinted at reconsideration if the Second Circuit failed to adequately address the issues at hand, further bolstering the likelihood of the petition's acceptance. The outcome of the Antoniuk case is crucial for everyone involved. It's not just about setting Supreme Court precedent again. It has direct implications for New York and potentially a bunch of other states, like California with its new SB 2 law on concealed carry. Personally, I'm part of the legal battle in California as a named plaintiff in the CRPA lawsuit along with Reno May. Right now, it's in the Ninth Circuit Court of Appeals. And from what we've heard in oral arguments, there's a chance they might just follow what the Second Circuit said in Antoniuk. They could decide SB 2 isn't exceptional and doesn't need to comply with Bruen. That's why the Supreme Court reviewing the Antoniuk case is so critical right now. It could impact laws across the country, shaping how these issues are handled constitutionally. Recently, in the Antoniuk case, things have been quite interesting. After the petition, Antoniuk was scheduled for Supreme Court conference a couple of times. It went in, came out, and we didn't hear any news, no orders, no updates. Then it got rescheduled, and I think that's happened twice now. The latest rescheduling and conference were around June 6th, so the following week, we were all waiting eagerly to see what would show up on the order list. Antoniuk on hold, waiting for Rahimi. Now here's the twist. During the conference for Antoniuk, they also discussed all those Illinois rifle magazine ban cases. But when the order list dropped, we didn't see a grant or a denial for any of them. Plus, there was no relisting of Antoniuk either. It seemed like a signal that Antoniuk was being put on hold. You might be wondering, what does that mean exactly? Well, typically, when the Supreme Court does this, it's a bit of a holding pattern. They're waiting to make a decision until they've handled a bigger, related case. So what's likely happening here is that the Supreme Court is gearing up to rule on the Rahimi case. That one's expected before the end of the Supreme Court term, likely by the end of this month or early July. Rahimi directly tackles how Bruen applies to the Second Amendment and federal restrictions on people with arms and ammo under domestic violence restraining orders. So, Antoniuk being on hold probably means they're waiting to see how things shake out with Rahimi before making their move. Looking forward, implications and timing. So here's the scoop on Rahimi. It originated from the Fifth Circuit, where the panel ruled that applying Bruen and the Second Amendment, certain federal restrictions were unconstitutional. Now the big deal is the Supreme Court gearing up to rule on Rahimi. With Antoniuk on hold, it's a clear signal that the Supreme Court sees Rahimi's outcome as pivotal for Antoniuk. After Rahimi, we're likely looking at a scenario where Antoniuk gets sent back down for the Second Circuit to reevaluate in light of what the Supreme Court decides in Rahimi. To sum it up, Antoniuk's on hold, not up for a new conference, which means it's waiting for the Supreme Court's Rahimi decision. We're hoping Judge Alito pens a favorable decision in Rahimi that'll set a precedent for cases like Antoniuk, prompting a fresh look at how the Second Circuit and others are interpreting Bruen. Hunter Biden case. Hunter Biden may have a chance at appealing his recent gun conviction on Second Amendment grounds, as federal courts are divided on the legality of the statute he was charged with violating. The law has come under scrutiny from federal courts following the U.S. Supreme Court's 2022 decision in New York State Rifle and Pistol Association v. Bruen. That decision said courts should turn to history and tradition in determining whether gun restrictions violate the Second Amendment. Attorneys for the president's son said they will vigorously pursue all the legal challenges over the June 11th jury verdict in Delaware, finding him guilty of illegally possessing an arm while being an unlawful user of or addicted to a controlled substance. He was also found guilty of 2 counts of lying on a federal form about his substance abuse. There's at least a chance Hunter Biden would win that appeal, said Adam Winkler.
Did you realize that Hunter had a drinking problem?
This trial to last about a week or maybe a little bit longer, with opening statements set to begin tomorrow morning.
It's a matter of, are we treating everyone the same?
100% political move.
While no federal court has struck down the statute as unconstitutional, some have said it doesn't hold up as applied in certain cases. In short, our history and tradition may support some limits on an intoxicated person's right to carry a weapon, but it does not justify disarming a sober citizen based exclusively on his past drug usage, wrote Fifth Circuit Judge Jerry Smith in one of those rulings. Nor do more generalized traditions of disarming dangerous persons support this restriction on non-violent drug users. Biden's trial judge rejected a constitutional challenge to the charge in his case. Legal experts said that Biden isn't guaranteed a win, even though the appellate court that would review his conviction said last year that, in the case of another non-violent criminal, another statute against felons possessing arms violates the Second Amendment.